we live?
3, 2, 1.
First case we'll take up this afternoon is State of Tennessee versus Megan Boswell, 72869. I think we're primarily here for a second bond motion, which was filed September 29th. There have been some other things filed, and I want to talk about some other scheduling issues, but are you going to have any proof, Mr. Sproles, with regard to your bond motion to reduce bond?
No, Judge, just argue.
All right. Was the state going to have any proof?
No, Your Honor.
Just argument?
Yes.
All right, go ahead, Mr. Sproles. And we've already had a bond hearing back in May 28 of 2020. So what I'm interested in hearing is what's changed since the last bond hearing.
Judge, do you want me to?
Yeah.
Or-
Either way.
Judge, our position and the purpose for filing that second bond motion is the proof has not changed since Your Honor heard that proof. The only difference is that Ms. Boswell has been in continuous custody since February 25th of 2020. So she is closing in on 2 years that she has been in custody. Through no fault of the state, the discovery process has taken that long just because of the volume of information that we're dealing with. And, in looking at the factors, we would assert that she is not a flight risk based on the factors that we have laid out in our motion. And we would remind the court that the purpose of a bond is to ensure continued appearance in court, not as a punishment. So we would ask the court to take a second look at her bond situation. And excuse me. And as you said, the difference since the court looked at it the first time is the passage of time that has gone on.
All right. I think one other difference is that she's now stands charged with first-degree murder. I don't think that indictment had come down.
Had it not, I trust Your Honor on that, but I'm sure we anticipated those charges at the time.
Your Honor, there's been one other difference. That is that since that bond has been set, we've asked for the aggravated enhanced punishment of life without the possibility of parole. We'd also point out the state's been diligent. We have a trial date, and we hope to meet each one of our deadlines. And for that reason, we oppose any reduction bond. And again, there's been no real showing of any substantial change that should change the court's setting of the bond.
All right. I appreciate counsel's argument, and I really appreciate the fact that the arguments were brief. Having heard no proof of changed circumstances other than the passage of time, and the fact that the grand jury has indicted her for first-degree murder and I think felony murder, the court's going to rely on the proof that I heard at the previous bond hearings, the findings of fact that the court made, and conclusions of law that the court made. And I'm going to continue the bond where it is now, and I'm going to deny the motion for reduction based on the proof and the findings that I made earlier in this case. Now, that brings us to, we're not set to hear the motion for change of venue or change of denier until I think April 7th when we set that. Is that right? But as I had mentioned before, the last time that this court had a new jury panel come in, we prepared a questionnaire which both parties reviewed and agreed to. And when Judge Rogers brought his new jury panel in, we had them fill out the same questionnaire. It was made clear to the jurors that they were not being considered for the jury in this case, but we were just needing information. And I've given both sides a copy of those hundreds and hundreds of pages of questionnaires. I haven't gotten all the way through them, so I don't have any statistics to provide. I will before the April 7th hearing. So I just wanted to put it on the record that both sides have those questionnaires now for those two jury panels.
Judge, on that issue, could we approach?
Yeah. All right. Okay. That's the main issues that I wanted to talk about. We've had the motion hearing for the bond reconsideration. Any issues that either side wants to take up?
Yes, Your Honor, for the state. And I think you had mentioned it briefly, alluded to it. We filed recently a few motions, one for reciprocal discovery, one for a notice regarding expert testimony regarding mental health and mitigation regarding any proof pursuant to State versus Reed case. And we've just recently filed those and provided those to defense counsel. We thought it'd be prudent to set a date for those. We have other deadlines to set a deadline for responses for those motions we've just filed.
All right. Both of those, well, two of the four motions, one of them is reciprocal discovery, and that's just a matter of course. Two of them have to do with the potential mental condition defense and or mitigation. And then one is a motion in limine regarding any potential 404B issues that might come up. And I see that with regard to the motion in limine, Mr. Sproles, on behalf of the defense, has already filed a response. And we may have to talk about part of that one. So when we went through our scheduling one of the things that I had inadvertently left out, which is why I haven't put the order down. I was waiting and till we had this hearing, was the mental defense or mental mitigation deadline. And what we need to do is give the defense enough time to, prior to trial, to gain that information if it's there, and then have the state with enough time to respond to it. I think what we need to do is have the deadline for the defense to file notice of a mental defense or mitigation be May 1st. And then that will give the state 30 days to respond to it. And we can hear, if there's any motion to hear on that or any argument, we can do that on our. Do you want to hear those during July 28th when we have the other motions?
It's too close up to trial. If we needed, it's hard to get one down.
I guess, Mr.
Judge,
Cross,
can we set that back about one, in the event that we needed to retain or have a expert review in the event there was, I think 2 months prior to trial would be cutting it a little close.
okay,
I think June would be appropriate. That would give us 90 days out. And I think that would give defense counsel adequate time to respond and determine what they're going to do. Mr. Sproles, you agree?
That seems appropriate to me, Judge. I was just thinking if we do decide to explore that option, that we would need to start with a evaluation at Frontier. And I don't know what their timing is like. So I feel like the May 1st deadline for me is doable. I can't imagine it would take them that long. But I agree with General Staubus that they're going to need a little bit of time if we do have that type of evidence.
all right. So you're going to have to make that decision pretty soon, though,
I agree, Judge.
to get whether or not Frontier Health can get it done.
I agree. And if we do decide to do that, can we just file an agreed order for the evaluation?
That's fine.
That okay, Joe?
Yes.
So you want to say the deadline to have your information filed be May 1st,
I'm good with that.
and then if we have to have a hearing on it, if we have that on June 24th, that'll give you 60 days almost,
Okay.
General, to get
That's
your
fine.
information together.
That's fine.
All right.
Anything else we need to take up? Emily? Judge, that's all we had to take up with those dates, those motions.
And
How long, if we have that on June 24th at 1:30, will that give us enough time? You thinking a whole afternoon will be enough? Or do I need to set it for 9?
I guess, I think we could do it by 9:30, but probably set at 9 out of abundance of caution. I'd
All
rather
right.
have time left over than not enough time.
All right. I'll add that to the scheduling order and I'll get that filed next week.
Judge, I guess that really just leaves, of the state's motions, just leaves the.
Motion in limine. We'll do that on that July 28th day. When we already have trial motions. I think that'd be appropriate for that day. Okay, anything else?
Not for the state, Your Honor.
All right. Looking at my schedule here, it looks like April 7th is our next day to be in court. I had set that at 1:30 originally. I have motions in another murder case that afternoon and the following afternoon, if it takes more than one afternoon. Why don't we start this I've got a few cases set that morning, but let's start this at 9 o'clock.
That's fine, Your Honor.
We'll
Are we talking about?
April 7th.
April 7th, that's
Mhm.
fine, Judge.
So April 7th at 9.
Excuse me. Put it in my calendar. Once I get the schedule ready.
Okay,
Thank you, Your Honor.
Thank you, Judge.
I'm gonna hand all these back to you because you need to file.